Maas, and I'm a mediator and arbitrator at JAMS. I think it's important to set the stage in mediation, and pre-mediation conferences are a terrific vehicle for doing that. You invite the input from counsel, you get the big picture, and you get a chance to feel if there are positions that are unrealistic or recalcitrant, and maybe get the message across that you need to shape your client's expectations, realizing that mediation is not all or nothing. These are people who either face a long road ahead of them in court or are in need of an opportunity to bring closure to a prickly dispute. And if you listen, facilitate, but don't be afraid to give a realistic view or a blunt reality check, and try to encourage people to become invested in a decision that will help them move on with their lives. And that's kind of my guiding principle in mediation. In preparing for arbitrations, I think the best place to start is the arbitration clause in the parties' contract. You open that up and you can find out what law is controlling, what rules will be followed, and any other aspects that set the scope of your authority. And then I believe that crafting a well-reasoned decision is critical, because somebody's not going to be happy. So you have to pick your words carefully, because they're going to have to live with your decision, and they want to know they were treated fairly, the law was applied, and all facts that were presented were considered. As a district court judge, my civil trial background was tapped by being placed on a panel that received assignments for complex civil litigation. And those are the areas that I'm practicing now with JAMS, which include professional liability and insurance coverage disputes, employment, municipal liability, and new areas, including commercial disputes. I had the opportunity to be involved in a multiple-fatality train collision case that bounced around the courts for a few years before it got assigned to me. Following a $24 million verdict, the matter went up to the Supreme Court, and in the end, I was affirmed on all fronts, including my multi-million-dollar sanction award, which is still used all around the country. That railroad case has taught me how to be more effective and efficient. You don't want people to get off track with things that have atrophied over time. Otherwise, it lays waste for years, which is what happens in complex litigation. Mediation and arbitration give you an opportunity to avoid that and get the job done.